Hey, it's James, Father's Rights and Resources, How I Got Custody. I want to talk to you about what I think is the number one weapon or tool in any kind of court case. And I'm talking about a deposition or one of the parts of discovery. I don't know why attorneys don't use this more often. Well, I do know when it comes to fathers, they're a bunch of sellouts and they don't want to help fathers, so they don't want to do any work. They just want to make easy money. Walk into court, say, oh, play Mr. Nice Guy and say, hi, I'm a dad. Please let me be a dad sometimes. Please, will you please? I've been talking to people all week how they had lawyers and their lawyers basically were telling them, arguing with them, trying to convince them why they can't go for full custody, why they can't do this, they can't do that. Oh, it'll look bad. Oh, it'll give us away and all this other stuff. And again, I have another video on dealing with bad attorneys where I cite the rules of professional conduct. An attorney is supposed to diligently represent you. They're supposed to communicate with you as to how to accomplish your goals, not somebody else's goals, not their goals, not what they usually do or their normal MO or that type of thing. They're supposed to at least communicate with you how to accomplish your goals. If I have an attorney, or if I ever want a deposition done on the mother, I may hire an attorney to do a limited appearance to do it, because that's about the only thing I think an attorney is good for, except for the 3 or 4 or 5 attorneys out there who are pretty good at what they do. Outside of that, attorneys aren't good for anything except doing a deposition, because it's a little bit easier for an attorney to conduct it. So if you don't know what a deposition is, maybe you don't even know what discovery is, but discovery is each side is allowed to discover anything on the other side in a court case, except that which the discovery rules don't allow. Things like stuff that's like harassing. If somebody wants to interrogate you about your sexual history, or if you were molested as a kid, or something that's not relevant, or overbearing or harassing, something like that, then that's the type of thing that is off limits in discovery. So you're allowed to discover anything. I think the rule says, and you can read it for yourself, just look up in Washington, you look up Civil Rule 26, I think it is, through 37, but it starts off saying anything is discoverable, or any matter is discoverable that's relevant to the case. So discovery is, sometimes you see in criminal court cases, they say, I want my discovery. A defendant says, I want discovery. I want to be able to discover everything that the prosecutor is going to pull out and use against me at my trial. Because you have a right to get ready for your defense and know what they're going to use against you. It's not like Law and Order, one of these movies where they pull out Exhibit A out their back pocket and say, Your Honor, I got Exhibit A right here, and it's a big surprise, and the whole audience and everybody doesn't know until the day of trial. No, you're supposed to disclose discovery. It's more of an automatic in criminal court, but in civil court, you kind of have to go get discovery. So if you want you want daycare records, you want to find out, let's say, if I'm in a court case right now, I want to find out everybody, and my baby's mom had custody. For those of you who don't know, I've had custody of my daughter since she was a baby. But if I knew about discovery right away, I would ask, who are all the people you allow to babysit my child? I might ask an interrogatory, which is questions that I usually don't know the answer to. Name everybody who babysits the child, their address, phone number, and then I'll do a background check on those people, daycare, whatever. And then I'll ask a request for production, which is another type of written questionnaire in discovery. I might say, hand over all the documents and receipts and contracts with the daycare provider and all the booklets and pamphlets you have from a daycare provider. Then I might do a request for admission, where I might know one of the babysitters, like let's say it's Joe Johnson. I might say, admit or deny that Joe Johnson is a babysitter. Admit or deny you knew Joe Johnson, that Joe Johnson is a sex offender. Admit or deny you knew he's a sex offender before you hired him. If the mother says, no, I didn't know before I hired him, she's screwed either way, because if she hired a real sex offender, then her parenting looks horrible because she doesn't investigate. So she's screwed either way if I get her to admit or deny those facts that I already know. So I might ask interrogatory for something I don't know. Who babysits the child when you're not around? Name all the babysitters. And then if I want documentation dealing with it, I'll do a request for production or producing documents. Give me the receipts and all this other stuff. I'll definitely do financial stuff, like give me all your tax returns for the past few years. That's very common, especially in divorce. And then I'll ask something I know the answer to, and I'll get her to admit or deny it. Admit or deny this or that. Admit or deny you threw a tray at James in the hospital when recovering from a C-section. Admit or deny you punched James on 3 different occasions. Then you came running after him. Admit or deny you grabbed James by the collar in front of his workplace. Stuff like that. But there's rules to discovery. Like in Washington, they have 30 days to answer that. If their answers are incomplete, then I got to go and do a discovery conference and talk to the attorney and get a new date. If they don't follow that, then I get a new date from the court. If they don't follow that, then I do a contempt motion. A lot of times discovery doesn't happen when somebody's being evasive for 2 months or 3 months. So that being said, the most effective way to get answers from somebody and get them to hand over stuff is a deposition. And a deposition, if you don't know, is when the attorney, like let's say my attorney is Bob Miller. Bob Miller will subpoena my baby's mom to his office. He has a right to say, lawyers have automatic subpoena power. Subpoena her to his office and then sit her down, and there's a court reporter there to put her under oath, and the court reporter holds all the exhibits, or I hold exhibits and I hand them over to the court reporter after I question them, and they mark the exhibits and they put them with the transcript later. And I grill the crap out of the mother, or my attorney grills the crap out of the mother. I could do my own deposition, but sometimes it's a little bit of pain in the butt to set it up or whatever. But if you think about it, those of you who know and some of you don't know, any big law firm deposes the crap out of people. If you get in a car accident and you sue Geico and they think it's your fault and you think it's their fault, they're gonna either interview you, and you don't have to voluntarily do that, but they'll send their attorneys to subpoena you to grill the crap out of you. Was the light red, yellow, green? Who was on your left? Who was on your right? Was it raining, wet, dry, blah, blah, blah. And if you have great answers, they'll go, crap, James got great answers. He's probably going to win. Let's just settle with him and give him $80,000 instead of $100,000 and go on a trial. But if your answers are crap and you contradict yourself, they'll fold their arms and sit back and say, screw you, sue us. We'll get you for a frivolous lawsuit, yada, yada. That deposition allows me, or a lawyer, and most lawyers that I talk to say it's the number one weapon out there, allows me to discover everything I need to know on the spot. If the mother lies and says, James is dangerous and I'm afraid that he's going to become violent, I'll have an attorney do a deposition on her and say, okay, when was he violent? Oh, never. Okay, why did you say that he was violent? Oh, I'm afraid. What are you afraid of? What have been the indicators? Oh, well, he just raised his voice. So what's wrong with somebody raising their voice? Have you ever raised your voice? Have you ever assaulted James? Have you ever hit him? What happened? Didn't you punch him in the chest one night and he got out of the car and then you chased him down and begged him to come back in the car? Stuff like that. Or if you're saying that the father is so dangerous, why did you propose a parenting plan that allows every other weekend? Well, I just don't want him to have him more than every weekend. Oh, so he's not dangerous to the child for 3 days out of the week, but he is dangerous the rest of the week? Where do you get that idea? These are you can grill the crap out of somebody before you have a hearing. But you know what? These stupid, idiotic, airheaded, dumb, moronic, cowardly attorneys who are lazy don't want to do a deposition because it's work. It's like scrimmage before the game. It's like trial before the trial without the forum. And you could get all the answers. And why wouldn't you want to know the answers to the test ahead of time? If you're about to go to trial with somebody, why wouldn't you want to know what their answers are going to be? So you can attack them and make them look stupid and know what your summary argument is going to be ahead of time. Some attorneys say, oh, that's going to give them a heads up, or we don't want to let them know we're going online and questioning. If you keep questioning them at a deposition, you'll have all the answers they could possibly give. And then if they contradict themselves, you can say, well, they said this is the deposition. She's saying he's dangerous now, but at the deposition, she confessed that he's not really that dangerous. I was just emotional at the moment. She just committed perjury. She's not credible. Believe me, I want custody. She's lying. You can't believe her. This is based on the credibility of the parties. I want custody. Award me custody. That's the short of a deposition being the number one weapon. I have a packet on my website on my winning docs with samples of discovery that I use that I was talking about earlier. So that's the number one weapon: deposition and discovery.